I'm Kevin Vance. I'm the director of the Center for Constitutional Liberty, and the mission of the center is to promote the understanding, the proper understanding of America's founding principles. And so tonight's guest is perfectly in line with that mission. And I also wanted to take this opportunity to publicly thank Anna Sluter, who will be leaving us at the end of this week. She has provided amazing support for the Center for Constitutional Liberty and helped us really expand, I think, our programs and offerings over the last several months and years. And so maybe we could all thank Anna this week, who hopefully can hear us. Also, I have, after the lecture, there'll be time for Q&A. The first 4 student questioners will get a free copy of Professor Arkes' latest book. If you already have that latest book, then just see me and we'll get you a copy of another book by Professor Arkes. And I'm going to introduce a constitutional fellow who will introduce Professor Arkes. So Isaac Michael is a constitutional fellow, also an honors student. He is a philosophy major. Theology, math, classics are his minors. And he's from Indianapolis, Indiana, and also recent champion of the regional moot court tournament with other constitutional fellow Jeffrey Schirmer. So Isaac.
Wow.
Hadley Arkes joined the faculty of Amherst College in 1966. He became the Edward Ney Professor of Jurisprudence in 1987 and held that chair until he retired officially in July 2015. But he has not retired from writing and speaking. He has carried that teaching into a new phase. He has become the founder and director of the James Wilson Institute on Natural Rights and the American Founding in Washington, D.C. He has written 8 books, 5 of them with Princeton University Press: Bureaucracy, the Marshall Plan, and the National Interest in 1972, The Philosopher in the City in 1981, First Things in 1986, Beyond the Constitution in 1990, and The Return of George Sutherland in 1994. 2 more books have been with Cambridge University Press, including Natural Rights and The Right to Choose in 2002, and Constitutional Illusions and Anchoring Truths, the Touchstone of the Natural Law, in 2010. His articles have appeared in professional journals, but apart from his writing in more scholarly formats, he has become known to a wider audience through his writings in the Wall Street Journal, the Weekly Standard, and National Review. Professor Arkes has been a contributor also to First Things, a journal that took its name from his book of that title. For 8 years, he wrote a column for Crisis Magazine under the title of Life Watch, and he has carried over that concern as one of the band of friends who formed the new web journal, The Catholic Thing. He was the main advocate and architect of the bill that became known as the Born Alive Infants Protection Act. The account of his experience in moving the bill through Congress is contained in an epilogue or memoir in his book, Natural Rights and the Right to Choose. Arkes first prepared his proposal as a part of the debating kit assembled for the first George Bush in 1988. The purpose of that proposal was to offer the most modest first step of all in legislating on abortion, and opening a conversation even with people who called themselves pro-choice. Professor Arkes proposed to begin simply by preserving the life of a child who survived an abortion, contrary to the holding of one federal judge, and that such a child was not protected by the laws. Professor Arkes led the testimony on the bill before the Judiciary Committee of the U.S. House in July 2000, then again in July 2001. The legislative calendar was upended by the aftermath of September 11th, but in March 2002, the bill was brought to the floor of the House, where it passed unanimously. To the surprise of Professor Arkes, the bill was brought to the floor of the Senate on July 18th by Deputy Majority Leader Harry Reid, and passed in the same way. On August 5th, Professor Bush signed the bill into law with Professor Arkes in attendance. President Bush. Professor Arkes has been the founder at Amherst of the Committee for the American Founding, a group of alumni and students seeking to preserve, at Amherst, the doctrines of natural rights taught by the American founders and Lincoln. That interest has been carried over now to the founding of a new center for the jurisprudence of natural law in Washington, D.C., the James Wilson Institute on Natural Rights and the American Founding, named for one of the premier minds among the American founders. Professor Arkes has drawn to this project a cluster of accomplished federal judges who have wanted to get a firmer hold on the natural law, and brought them together with some gifted teachers of philosophy and law. The purpose of this new James Wilson Institute is to teach anew to lawyers, judges, and students those principles of law that furnished the guide to the American founders as they set about framing a constitution. And the hope is to restore to a new generation the furnishings of mind of the men who formed this regime. And in line with that work, he has brought out, in the spring of 2023, his new book, Mere Natural Law, Regnery Gateway. So Socrates was said to bring philosophy down out of the clouds, to bring it to bear on those questions of right and wrong, of the just and the unjust, which arise for ordinary people every day. And in the same way, mere natural law is meant to bring natural law down out of the clouds, not a foggy theory hovering in the sky, but those precepts of common sense that form the grounds of our most practical judgments every day, at every turn. The ordinary man may grasp them as readily, or even more readily, than professors, who have schooled themselves in theories of every kind. As the great Scot philosopher Thomas Reid once said, they are the precepts of common sense that any man needs to grasp before he can start trafficking in theories. And yet more than that, they are the things he is compelled to take for granted just to get on with the business of life. Please join me in welcoming Professor Hadley Arkes.
Oh, you read all of that. What's your first name again?
Isaac.
What?
Isaac.
Isaac, you got a great question this morning.
Thank you. Thank you.
Isaac, thank you so much. Isaac gave us a session today. He had the best question. I would invite him to just speak more directly on that question today. But, well, and I get an introduction like that. I usually say, look, I just came in to read the meter, and they asked me to stay behind and offer a few words. Thanks for that lovely introduction. It's my first time back in about 10 years. I'm just so taken. Everything looks so appealing. There's been a growth in everything. I just love the tenor of things here. I'm just so pleased to be back. A personal note on this, you know, I've lost so many people close to me recently that I really wondered whether I'd make it to see this book come out. And but it draws me back to that line in Tom Stoppard's play, The Invention of Love, when he does a kind of, has the young A.E. Housman at Oxford doing a riff for his young sister on God's words to Moses as he's showing him the promised land that he will not enter. And he has God say to Moses, I'm giving you all of Gilead unto Dan. I'm giving you all of Naphtali. I'm giving you all of the land of Ephraim and Manasseh and Judah to the utmost sea, but not including Wales, which I'm saving for the Methodists. Okay. Well, I'm glad to be here. I'm glad to be here and alive. Tom Stoppard wrote a book called Rosencrantz and Guildenstern Are Dead, and some friend asked him, what's it about? He said, it's about to make me a lot of money. So I don't think it'll make me a lot of money, but I hope it'll make my publisher, Tom Spence, some money. But I want to move to cut off at the pass. Some of the cliches most likely to be triggered by the mention of mere natural law. My dear friend Russ Hinninger pointed out that Lincoln could not have raised his arm on March 4th, 1861, and taken an oath to preserve the Constitution if it were thought that the Constitution now contained that constitutional right articulated by the court in the Dred Scott decision. Because Lincoln had led a national movement to counter and overturn that decision. Now, I've aligned myself over the years with the Lincolnian position here, that if the court declares Dred Scott to be a slave, we will not form a mob to free him. We will respect the outcome of the case in regard to those two litigants. But if we are not persuaded of the principle articulated in that case, then the political branches are not compelled to make that principle the ground of the judgment for the things that come under their hands. And the Lincoln administration moved right away to reach decisions that were at odds with the Dred Scott case. They rejected the argument that blacks could not be citizens of the United States and therefore not carry passports to study abroad and not gain a patent under the laws of the United States. And in 1862, Lincoln and his Congress moved to bar slavery from the Western territories, anything in the Dred Scott decision notwithstanding. The issue arose in the mid-'80s as to whether the National Institute of Health were obliged to use in the research tissues drawn from elective abortions. I was part of the party arguing at the time that if Lincoln was right, the Reagan administration was in a position to say that we never accepted the principle articulated in Roe versus Wade. And therefore, in the judgment of this administration, those tissues were drawn from surgeries we regard as wrongful. We argued that could be wrong only if Lincoln was wrong, and we didn't see anywhere under the logic of this Constitution that Lincoln could have been wrong. My point is that this teaching on natural law is not a doctrine that gives an unconstrained discretion to an expansive judiciary. The argument, rather, is that judges who understand these principles of natural law will have rather a sharper understanding of the hard boundaries that mark the limit to the inventiveness and reach of judges. I had the occasion to sound this argument in the hearings that Isaac mentioned over the our Born Alive Infants Protection Act, and I was twitted by my old nemesis, Jerry Nadler from Greenwich Village. He said, well, Professor, maybe we should try our hand at revising another case like that case called Bush versus Gore. I said, Congressman, you really should try your hand to get practice at it. But just remember, you still have to honor the outcome in regard to those two litigants. Okay? I've been doing round-the-clock interviews on this book and podcast. At times it's been rather like Brian Lamb at C-SPAN. Would you remind our listeners who again was Lincoln? And people would say, Professor, could you explain to this audience what is natural law? Fair question. So I dip into Immanuel Kant and Aquinas and tell them it's the laws that underlie all of our laws that tell us why we're justified in having positive laws. We see the signs saying 65 mph, 35 mph. But behind those laws, as Kant would tell us, is an underlying natural law that tells us why we'd be justified in restraining the freedom of people to drive at speeds that put innocent life at hazard. And the task, as ever, is to make a translation between that underlying natural law to bring it to bear on the circumstances and terrain before us. 65 on the open highway, 35 on the winding road. But the natural law also brings us back to that matter of who has the authority to make that positive law in the first place. I was on a platform years ago with that professor from Notre Dame, Amy Coney Barrett, and someone asked her, why do you have such reverence for the positive law? What makes the positive law in America stand on a higher plane than the positive law in Stalin's Russia? And she was big taken aback by the question, because not what she was used to. And the key really lay in that string of three questions from John Locke. What is the source of the law? The legislature that makes the law. Well, then what is the source of the legislature? A constitution that tells you whether you have a legislature, how many parts. But then Locke asks, but then what is the source of the Constitution? It must be, he said, some source wholly antecedent to the positive law. In our case, it took this form. Though man is by nature the ruler of other men, the way that God is by nature the ruler of men, men are by nature the ruler of dogs and horses. The only rightful government over human beings depends on the consent of the governed. To which my dear friend Antonin Scalia said, that's a wonderful sentiment. It's not part of our laws. It's never been enacted. And the response was, of course it couldn't be enacted. It was the principle or point that had to be grasped in the first place before we knew who had the authority to enact anything. Okay. I want to go back then to the principles that were there before the Constitution. So mere natural law, I drew upon a sense of things in the things before the positive law. I drew upon C.S. Lewis's Mere Christianity. We pointed out that in the conversation of children, we find the rudiments of moral reasoning. They're not really arguments over likes and dislikes. They're having moral arguments of things that are right and wrong. And they're bringing forth rules. We did that last week. Why aren't we doing it this week? They're bringing forth rules. And the conversation makes no sense unless everybody assumes their standards for judging right and wrong answers. So the move here was to go back to those common sense principles of moral reasoning that children and ordinary people will grasp before they've been immersed in theories of all kinds. A former president of Amherst College said, Hadley has a theory of natural law. I said, when you say that, you're rather suggesting you're standing back in wholesome detachment, watching theories whiz past. And somehow you're able to form judgments on the strands of those theories that are plausible or implausible, true or false. I said, take me back to the ground on which you're making those judgments about the things you reliably know, and you'll be back in the ground that some of us take to be the ground of the natural law. My dear late friend Dan Robinson, who wrote 18 books and ended his days lecturing at Oxford, says he won on his tombstone, he died without a theory. Without a theory. He's drawing on Thomas Reid and those lines that Isaac revealed to you. Thomas Reid, the great 18th, 19th century philosopher, with his doctrines of common sense, who's invoked by James Wilson in the opening lines of the first case ever reported in the Supreme Court reports, Chisholm versus Georgia. Thomas Reid, speaking of those principles of common sense, that the ordinary person not only has to grasp, as Isaac said, but has to know just in getting on with the business of life. And so the pitch was, before the average man would start bantering with David Hume about the meaning of causation, he knew his own active powers to cause his own acts to happen. The leading figures of the founders, Alexander Hamilton, John Marshall, James Wilson, showed a remarkable knack of tracing their judgments back to those anchoring axioms for the sake of explaining the grounds of their judgments. And so John Marshall, in a kind of throwaway line once in Gibbons versus Ogden, apologizes to his readers for spending so much time demonstrating what should be in the class of an axiom. He assumed that all of his readers know before you could do a demonstration, certain indemonstrables had to be in place, things to be grasped per se nota, like the law of contradiction. If you didn't grasp that, I couldn't explain it to you in the form of a demonstration. That's one of the things you had to grasp before you stepped into the demonstration. And the founders were utterly clear on this point. It was never expressed with more elegance and economy than by Alexander Hamilton. In that preface, he struck off to the Federalist 31 on taxation. And in the course of that paper, he reached no conclusion different from what, say, Chuck Schumer or Mitch McConnell would reach in our own time. But anyone looking at the text would notice some strikingly different furnishings of mind. Because this is the way Hamilton put it. He said, in disquisitions of every kind, there are certain primary truths, or first principles, upon which all subsequent reasonings must depend. These contain, he said, an internal evidence, which antecedent all reflection or combination command the assent of the mind. Of this nature are those maxims of geometry. Two lines cannot enclose a space. Two things equal to a third are equal to one another. And of like nature must be those maxims of ethics and politics. There cannot be an effect without a cause. The means must be proportioned to the end. There ought to be no limitation placed on a power destined to effect a purpose which is itself incapable of limitation. Just the way Chuck Schumer would have said it, I think, if he bent his mind to it. When Hamilton referred here to things that could be grasped per se nota, he's referring to things so fundamental that they could be readily grasped by the common sense of ordinary folk. Aquinas said the divine law we know through revelation, but the natural law we know through that reasoning that is accessible to human beings as human beings. And in my teaching, I found no example which, when offered, is more instantly understood as an example of natural law reasoning than that fragment Lincoln wrote for himself in which he imagined himself to be engaged in a conversation with an owner of slaves, putting the question, why are you justified in making a slave of the black man? Is he because he's less intelligent than you? I'll beware, the next white man who comes along, more intelligent than you, may rightly enslave you. Is it because he's darker than you are? I'll beware again, the next white man who comes along with a complexion even lighter than yours may enslave you. The upshot here is there's nothing you could cite to disqualify the black man that would not apply to many white people as well. And some of us drew on just the same natural law reasoning on the matter of abortion. Why is that offspring in the womb anything less than human? Doesn't speak yet? Neither do deaf mutes. Doesn't have arms or legs? Other people lose arms or legs in the course of their lives without losing anything necessary to their standing as human beings to receive the protections of the law. There's no appeal to faith here. It's simply this. You don't have to be Catholic to understand this position. In fact, that has been the position of the Catholic Church. We're not appealing to faith. We're giving you a combination of embryology and principled reasoning, something that everyone is capable of understanding. But what were some of those other critical things to be grasped per se nota? Well, for one, that anchoring axiom in the laws of reason, the law of contradiction, that two contradictory things both cannot be true. The man on the street may not know the law of contradiction, but he knows when people are telling him conflicting stories. And the other one, the most important one, is the one that Kant and Aquinas regarded as the truly first principle of all moral and legal judgment, and which the ordinary man understands at once when you give him this question. What would he say if you're told that Jones, accused of a serious crime, was undergoing surgery at the time the crime was committed? I think the ordinary man would wonder, or that he hadn't been born yet. The ordinary man would wonder, why are you punishing him? But what he grasped at once is that first principle, expressed in different ways. Kant would say, the moral world begins only with the world of freedom, where people have the power to cause their own acts to happen. It makes no sense to impose judgments of praise or blame on people for things they were powerless to do. And Thomas Reid says that proposition is true as anything in Euclid. We don't hold people blameworthy for acts they were powerless to effect. But that proposition, from that simple proposition, I could extract a whole string of things that run through our law. It may also explain the wrong of racial discrimination. You know, we used to raise the question, if kids were separated on the basis of race in the schools and the reading scores went up, would the segregation still be wrong? Would it cease to be wrong? Or was it simply wrong in principle, regardless of what the reading scores had it? I think the wrong here does resolve into some matter of holding people blameworthy for conditions they were powerless to effect. This is something I stumbled onto years ago, almost 50 years ago, in a piece for the Supreme Court Review, with one of those rare mistakes that the great Robert Jackson made in a case involving racial defamation in Chicago, defaming a whole racial group. He said, well, what's a case of defamation? We should have people prove the charges he's making against black people, even though he doesn't have the remotest chance of proving it. Remotest chance of proving what? That if you let people into the neighborhoods, you'll be mongrelizing the race, along with violent aggressions, rapes, robberies, knaves, marijuana. What he instantly recognized is that we can't impute guilt to any particular person based on what is known in the aggregate of that racial group which he happens to be a member. To do that is to back into a kind of theory of racial determinism. That if we know the race, we know that race determines the course of moral conduct, right? As though somebody's gone governed by something outside of his control. Every one of us is a member of a race. If every one of us was determined in our conduct by race, none of us would be responsible for his own acts. It's simply inconsistent with the deepest premises of moral and legal responsibility. Okay? But let me just draw a couple of other things out of that first anchoring point. We don't hold people blameworthy for acts they're powerless to effect. We hold people responsible for their own acts as we judge them. But we insist they should be punished only for wrongdoing. And if we respect the difference between innocence and guilt, we insist that we make those judgments by testing evidence in the most demanding way, according to the canons of reason, rather than have people run over hot coals or outrun a mob on the street. And if we keep taking this a step further along the way, we reach this point. We say that anyone accused of a serious crime should have access to the witnesses and evidence against him for the sake of rebutting them, and in rebutting them and arriving at a verdict that is substantively accurate in discriminating between innocence and guilt. And if you understand that, we're saying that if we draw out the moral logic of the law, we would come to a right of a person accused of a crime to be confronted with the witnesses against him. And what we're saying is this implication arises out of the very logic of law, and would be there even if there were no Sixth Amendment. Okay. I was going back, I meant these earlier passages with the John Quincy Adams saying, that right to petition the government, it's simply implicit in the idea of a free society. It would be there even if it were not mentioned in the First Amendment. It'd be there even if there were no First Amendment. It'd be there even if there were no Constitution. In the old Dartmouth College case, John Marshall said, to impose upon a people a contract they did not wish could be as wrong as impairing the obligation of a contract they willingly made. And Justice Story would say years later, that proposition would be true even if there were no Constitution. So I'm saying is, the logic behind the Sixth Amendment was there before and in fact, remember, the Sixth Amendment was not part of the original text. They added it later. They never added innocent till proven guilty. And years later, my great friend, the great George Sutherland, would deal with the Scottsboro case of these young black kids who hopped on a freight train. They're involved with white girls, accusations of rape. The case was heard in the 30s in a hostile Alabama town. The kids were distant from any help. They had didn't know how to hire a lawyer. They're detached from friends who would help. And Sutherland looks at this case and says, whatever this is, people had a rather casual attitude about going around arranging account. Whatever this is, it simply isn't consistent with the rule of law, a real trial. What people seem to miss is that George Sutherland did not take that as an occasion to incorporate the Sixth Amendment now against the states. What he's telling us is this would be wrong even if there were no Sixth Amendment. And it would be wrong even if there were no Constitution. Now, I want to take that issue of determinism to take the other thing, another point that runs through our law more than anything else, I think. In that debate between Lincoln and Douglas, Stephen Douglas, which is taught at this college, Douglas insisted that the laws had to be adjusted to the interests of different states. So he said in Maine we had laws on oysters. In Indiana we have laws on cranberries. And some places use slave labor. And Lincoln thought this was what they call a category mistake. He said, I don't think cranberries and oysters stand on the same plane as slave labor. Cranberries and oysters are morally indifferent things. What do we mean by morally indifferent things? You ask the man on the street, if you're told about someone, that he was short or tall, heavy or thin, he's dark or lighter, that he stutters, that he's deaf, can you make any inferences as to whether you're dealing with a good or a bad man who deserves to be welcomed or shunned, praised, or blamed? The common sense of the matter, I think, grasped by most people, would be explained by the philosophers in this way. That we're dealing here with attributes wholly wanting in moral significance, meaning that we cannot impute to any of these features, height, weight, deafness, we can't impute to any of them a deterministic force in controlling and determining the moral character of anyone and drawing moral emphasis about anyone. The most dramatic example I could give you on this head was the case of the Baby Doe case in Long Island in the mid-'80s. And I was in the courtroom the day that Chuck Cooper argued the case in the Supreme Court. Something missing here? Oh, I'm okay. The Baby Doe case, which is a baby born afflicted with spina bifida and Down syndrome. And the parents and the doctors made a decision to withhold medical care from that baby. And the Reagan administration, my people, went into court. The administration was demanding that you have futile surgery if the surgery was just impossible. They wanted to know the grounds on which the medical care was withdrawn. In the court below, the great Ralph Winter said, if you withdraw medical care because the child is too dark or black, that is not a medical judgment, but a moral judgment. And if you're withdrawing medical care now on the ground that a life afflicted with spina bifida and Down syndrome is a life not worthy of living, that is not a medical judgment, but a moral judgment. And a moral judgment drawn wrongly from an attribute, spina bifida, an affliction, that could not possibly have any deterministic force engaging the moral character of anyone and the capacity of this child to live a life of moral purpose, even in a diminished state. Now, if that distinction that Ralph Winter and I are making, if that makes sense to you, that there is a difference between a medical judgment and a moral judgment, that the moral judgment was drawn wrongly from attributes of a person that cannot possibly determine anything of moral significance about this baby. If all that makes sense to you, I think the question almost naturally presents itself. If we shift the locale and the action isn't taking place in Long Island, but in Tehran or Nairobi, would the judgment be any different? Would not be just as wrong in any of these places, distant in time, place, to withdraw medical care on the ground that a child afflicted with spina bifida or Down syndrome has a life not worth living? If we recognize that simple point, we recognize that this judgment of ours about the wrong of drawing moral inferences about people on the basis of these attributes is not some ethic that prevails in this tribe of Americans. The judgment is grounded in nature, in the laws of reason themselves, in truths that can be grasped by any functional person. And there's nowhere in the world they would not hold true. So without any sense of astonishment or any sense we're doing it, we'd find ourselves back again into that N word that dare not speak his name, the natural law. But at the same time, we consider that you see that in striking contrast to the cliches we hear so often, there's nothing the least foggy about these principles. They may be precise and concrete as they bear on the cases before us. There is nothing inscrutable about them. And they do not suddenly become woolly or inscrutable to any man if he puts on the robe of a judge. Now, this jurisprudence I've been describing finds its ground in real principles. Proposition is true of necessity, and anyone working with the sense of things knows that the natural law cannot tell us what the right price in nature is for a pair of pants or a gallon of milk. When judges cultivate this kind of an understanding, their dubiety is engaged at once when they encounter policies like wage price controls or rent controls. And in that vein, my dear friend, Judge Janice Rogers Brown, once raised the question, why was it wrong for the Heinz Energy Company to market milk at 60 cents less of a gallon in Southern California? And why does that state of affairs constitute a, quote, disorderly market condition that the government has any justification in reaching? The judges who absorb this understanding of natural law will not presume to tell us how long of a residence requirement it will take before a community would be obliged to pay for a publicly funded higher education for a resident alien or the children of illegal immigrants. These are judgments that depend on the generosity and the means of the local community. They should be made by political people in elective office who have a closer connection to the sentiments and the means of their communities. There is nothing in the toolkit of judges that gives them the means of making those kinds of decisions. And so again, the upshot here is that a judge who is sensitive to this scheme of natural law is a judge who's likely to have a sharper awareness of the limits to the reach of judges themselves. And Isaac stole my line. It was said that Socrates brought philosophy down out of the clouds. He stole it because I guess I must have put it in that sheet. He brought it down out of the clouds to bring it to bear on these questions of right and wrong that arise every day. And we think it now, what we're trying to do is bring natural law down out of the clouds, what people regard as some kind of a foggy theory hovering somewhere. So I've said before, to ask whether the judge can get through the day without relying at every turn on the strands of natural law is rather like asking, can I order the coffee without using syntax? You know, he's using it every time, even when he's unaware that he's using it. The statute bars racial discrimination in certain private businesses open to transactions with the public. Do we assume that this law should be applied universally to everyone, equally to everyone who fits the description in the statute? That's a distinctly moral logic. Who put it there? The Constitution doesn't tell us to do it this way. Or is it a logic we've ever attached to things we understand law to be? Let me end with this story. About 20 years ago when I did that book, Natural Rights and Right to Choose, reflecting upon our experience in passing the Born Alive Infants Protection Act, I did a talk at Fordham at the law school, and after dinner, I had dinner with a dean who said, the dean said, the judge in that early period did not write much about natural law. To which my friend Dan Robinson said, yes, they didn't write much about the alphabet either. It just threaded through everything they did. And then it struck me that what was going on here was a species of what the philosophers would call the category mistake. You're building things together. She arrived in a sedan churn and a veil of tears. You're mingling things that quite belong together. And I realized what I was facing was something like that, what Gilbert Ryle called a category mistake. And it's something like this. I say, a visitor came to Amherst College when I was there. I showed him that beautiful room where I taught. I took him to the playing fields, to the social center, to the earth sciences building, the administration building. We go back later for drinking. I said, that was all very nice, but I thought you were going to show me the college. Then I realized what's happening is this. I have these lawyers telling me, look, all you've shown me is how a bunch of very literate lawyers at the beginning trace their judgments back to axioms and rights that would be there even if there were no Constitution. When are you going to show us how they did natural law? I said, we just did. Thank you.
Great. Half an hour for questions.
I should have, I think we're pressed for time. I should have used an old device of mine to compress my talk Hebraically by omitting the vowels. It sounds like Welsh, but we save time. Okay.
Let's start with some students. Yep.
I'm Jeff Schrimmer. Nice to meet you. Thank you for your time.
I heard you quoted by your president about the new library.
Great.
That's a place. Other places teach people to hate America. This place will teach people something morally right and true about the founding of this country. Well, good for you. Thank you so much, Jeff.
Thank you.
Okay.
And thank you for your talk. J. Joel Alisea came earlier this year to talk to us about originalism.
Who can?
J. Joel Alisea.
Oh, I know him.
He knows you.
I know him since he was a student of Robbie George's. Yes. Okay.
And so I'm wondering how you respond to his contention that basically judges themselves, the judiciary specifically, is bound to the historical inquiries of originalism simply because the determinations of the natural law and taking into account the natural law is more proper to the other branches under the constitutional structure that we particularly have in the United States.
There's something in the Constitution that bars moral reasoning to people when they're judges.
I think that would be his contention, that historical inquiry alone.
You should see my response to him in the National Review, which they were supposed to have said it, given more prime to. No, it's the judges would regard this as heresy, because as one historian said, the founders didn't put in the Constitution everything they knew. In fact, they didn't even want to. James Wilson didn't even want to mention ex post facto laws, making something punishable that was not illegal at the time it was done. Everybody knows that. You don't have to put that down. We didn't put down anything about in the Constitution about the text. Remember about the right to confront witnesses against you. We'll discover some things as we go along that we'd forgotten about. But the example I used today, if you have time for it, was mentioning to your president. Take that. And in fact, the one I threw up to Joel himself. And he said that the judges didn't do that. He said the one that counts decisively against your argument was John Marshall's elegant argument in Fletcher versus. He told us judges don't do it. He did it magnificently. Let's recall what he did. You have a law in Georgia which rescinds a grant of lands because of corruption. It was taken to annul a contract, an obligation. So they could have decided this case simply under Article 1, Section 10 of the Constitution, the impairing an obligation of the contract. But Marshall took this as a moment of teaching. Instead of doing it that way, he did something far more elegant. He showed how the contract clause could be drawn deductively with the force of a syllogism from a deeper underlying principle on ex post facto laws, not making something punishable after the fact. Then he put himself in the position to say this. Georgia is a great state. It's part of the American empire. But even if Georgia were a separate sovereign state, outside the Union, outside the Constitution, outside Article 1, Section 10, this law would still be wrong because its wrongness is rooted in a proposition, in a principle that does not at all depend for its validity on being mentioned anywhere in the text. I brought back to Joel. He was given the chance to reply, and he never replied. But the point of it is that they just did it all the time. It would come as a surprise to people of that generation to say that, well, we can't do that. And look, it's, as I mentioned it to the president a while ago, in the case of the 50s, Felix Frankfurter had a case of, on the Fifth Amendment, should not be compelled to be a witness against himself. He said, where does the accent lie? Is it against himself? If we give him immunity, can we compel him to testify against his friends in the Communist Party? Or does the accent lie on compelled, evidence extracted under compulsion? The point is, even with those lines in the text, judges had the need to keep going beyond the text, to remind themselves, what is the principle that makes sense of this whole thing? So they're doing it all the time. And it takes, forgive me, the onset of heavy theory, of a theory of positivism, this new version of originalism, to tell us why we can't do this. We have a new theory that we're proposing. as Judge Edith Jones said in response to Joel's critique, he said, what he doesn't understand is you're offering the original originalism, that is the Constitution as it was understood in its moral ground by the people who made it, and not the Constitution seen through the prism of Justice Holmes's positivism. So, okay. But as late President Nixon would say, I'm glad you asked that question. Yeah.
Hello.
Hello.
Thank you so much.
How are you?
I'm well, thank you. Thank you so much for your talk. My name is Elizabeth Peterson. I wanted to talk to you about how you mentioned that with Lincoln, he basically said like he wouldn't act outside the confines of the law once the Dred Scott case had been decided. So he wasn't about to like go and try to change the law unilaterally.
He would not challenge that verdict.
Right, he wouldn't challenge the verdict.
He's certainly going to argue about the whole terms in which it was argued, yes.
Exactly, but he didn't believe in the underlying moral framework. So Lincoln, in his position as like president and leader of the Union, couldn't do anything to like bend the law unilaterally of his own free will because that just wasn't a part of his powers. But like if he had been a private citizen in his practice as like a private citizen, how do you think he would have felt about like people who technically broke the law by helping slaves escape? So kind of a form of civil disobedience, while not like changing the law, still like acting outside the boundaries of the law as written.
Well, he did an interesting response to that question about the fugitive slave clause, requiring the return of fugitive slaves. He said, maybe it's in the law, but the law is silent on the question of whether we presume, we find a black man in the North, do we presume that he's a slave and put the burden of proof on those who claim him to be free, or do we presume that he's free, by nature free, and put the burden on those who claim him to be a slave? He has the positive law of the Constitution, but he reads the positive law against the deeper principles of the Constitution, the principles of natural freedom and natural right. It's simply a twist of presumptions. But that's what's going on all the time. I know he'd appeal to the deeper principle. With the suspending the writ of habeas corpus, my friends get even Scalia would argue about that one. Look, he said, William Henry Dana, the author of what's the great novel, arguing before the Lincoln administration on the prize cases, said, a war is a fact, a declaration of war, he said, is an artifact of legislation, but war is a fact. And an adversary may not be decorous enough to attack you only when Congress is in session to enact war. You have to assume that the authority to defend the country is in the hands of the one branch of the government that is never out of town and never out of session, the executive branch. And then the crisis comes, suspending the writ of habeas corpus. The founders recognized that there could be a time of danger which it could be necessary to break a rebellion, to suspend the writ of habeas corpus. But only when Congress was in town, when it was the object of the rebellion was to keep Congress from assembling in the first place by cutting the rail links. So do you assume that the authority to act under the Constitution, which the founders recognized the authority was there. Now the question is, did they really think that those were justified in defending the country and fending off a rebellion by suspending the writ, but not if Congress is out of town? Or does it make more sense to reason as Lincoln did, that the authority must hold to the branch that is never out of session, and to make the act until Congress can get there to provide the legislation? I used to say that if the founders didn't see that, the founders got it wrong. I mean, Lincoln was so compelling on this point that I think he did. No, he there was this recognition, people would be teaching it all the time. Somebody was doing, but Nathan Orlando was dealing with the Lyceum speech about the recognizing, there are two great souled men. There are these great souled men who rise above the law to become the destroyers of republics. and they're great souled men who rise above the law to become the saviors of republics. And Lincoln recognized there's a time in the country, a time of danger. Who would have the right to make these decisions? Some unelected judge? No. Or it could be a moment when the laws have to be suspended, and your hope is that the one who suspends them will bring it back to the laws as they were to restore the regime. And Harry Joffe's argument was that of those two men, two great-souled men, the one who was more superior yet was the one who took on that measure of self-control. He knew he was a superior man, but instead of using that superior power, he used that power to return the regime to the regime it was. I remember Lincoln said to some group of soldiers, I myself am evidence that this regime is what, where else could someone of my background come to this kind of position of authority? With Lincoln, the commitment to a Republican government, governed by the Senate, that was just deep in his soul. There's no way he would have been disloyal to that. And so what we're saying is, it's beyond structure. You can't structure this thing. You can't create a structure. At a certain point, the decision is going to have to be made by someone, and it's going to depend on the character of that person who's making the judgment. Okay? That may be the last word I should say to you, but maybe, is there another question? Okay. I'm sorry, I might have plagiarized. I might have filibustered. Can you shout it out? Oh, I got you.
Thank you for coming. My name is Carlos. I'm from Texas, and with the premise of, I guess, like the train of thought of you can't hold someone accountable for things they are unable to affect, and with the Constitution, obviously, things are enshrined in our country, freedom of religion and freedom of speech. How should we deal with, I guess, the rise of Islamophobia in light of recent events with people openly threatening the United States, the West? I've dealt firsthand with slight threats in the workplace. How do we deal with things like that? And is it constitutional, and is it like against natural law to refuse people the right to peacefully coexist with us? I mean,
whoa, you got 10 questions. You got 10 questions there. An ensemble. You're talking about Islam, people who. I think this Islamophobia is quite exaggerated. There aren't that many attacks. They're trying to make moral equivalence. Sure, to attack somebody by drawing inferences about Islam, of course, would be wrong. What we're seeing now is something I've rarely seen in my life. I was born in the middle of 1940 when a murderous Nazi regime was on the move. France had fallen. And after the war, we didn't see much anti-Semitism. It was just Gentiles-only signs, things like that. I never saw people coming out in the streets saying now that to behead babies and to kidnap grandmothers was all justified without being asked the question, what do you take to be the nature of the wrong that justifies savage acts of that kind? People are no longer in the colleges confronted with the question of how do you justify these moral judgments you're making? Those have disappeared. The Constitution is, this is not a doctrine, Constitution based on moral relativism. When the founders invoked in the Declaration, the author of the laws of nature, including the moral law, the God of the Declaration was not indifferent to Satanism or radical evil. Some of our things people say, if we have religious freedom, it must include everything that calls itself a religion, including Satanism or the Church of the Flying Spaghetti Monster. It is radically wrong to assume that this Constitution, in its understanding of religion or anything else, was based on such doctrines of relativism. We are not delivered from the need to reach moral judgments, even about some things that are taught and offered under the name of religion. It could be sacrificing babies, sacrificing widows on the funeral pyres, and so on. So again, the Constitution that I'm giving to you, is one that, look, I mentioned to the President, James Wilson in the first case, Chisholm versus George, is saying, invoking Thomas Reed, standing against that moral skepticism which under bold for false colors prevailed in Europe at the time you wrote. And the point was, we begin the American Constitution by understanding that we must detach ourselves from moral relativism in all of its ground. You cannot reach this Constitution on the basis of moral relativism. The Constitution is defensible only on the basis of those, yes, necessary truths. James Wilson thought that proposition, we don't hold people blameworthy for acts that are powerless to effect, was a necessary truth. There's no coherent way to deny it. It is not simply a theory that it is wrong to hold somebody blameworthy for acts whose powerless to effect, nor is it merely a theory that two contradictory propositions both cannot be true. So what I've been trying to present to you, invoking Wilson and others, is this. If you follow them, that a system of jurisprudence can in fact be drawn from these grounding axioms, true of necessity, what we're not giving you is a theory of natural law. We're giving you the real thing. It's the real thing. Well, as one judge once famously said in the common law, I don't know whether by these remarks I've settled the law or unsettled the law, but I hope I may put it in a position where a mind better than mine may one day settle it. Thank you all for coming out. And I vote for the pumpkin pie, by the way. Thank you.
Thank you all very much. And same time on Friday, same place. We're co-sponsoring another talk with the theology department here with DC Schindler.
Philip Wheel brought you over for a speaker.
Were you there? Father, what's... Yeah, aren't you guys been watching me and reading me someplace before? No, oh, it must have been 10 years ago. 10 years ago. I think I remember things in the 90s more readily than